Good afternoon. It's my pleasure to introduce our next speaker, John Myers, who is a professor of law at the McGeorge Law School at the University of Pacific in Sacramento, California. Mr. Myers has written extensively on the topic of child protection. He's developed a handbook on child maltreatment, a book on the history of child maltreatment in the U.S., and has authored multiple articles on the testimony in child sexual abuse litigation, the legal representation of children, and children's rights in the child welfare context. John has also produced training videos about testimony in child sexual abuse litigation. He's received multiple awards for his work, and he continues to practice law in representing children and family in juvenile law cases. I imagine he's popular with his clients because he has very cool business cards that he hands out to his children. And one interesting fact about John is that in the past year, he participated in a race car race and won. But he could show you pictures of his race car, which is very cool. So I'll turn it over to John.
Yeah, Jimmy Johnson and I have a lot in common. I'm the warm-up act for Elizabeth Smart. So we'll try and get the audience ready to go. Again, I'm John Myers. I'm a lawyer. I'm a law professor. So I'm going to be talking about what I know about, which is the law. And I hope if you have questions, you'll ship them up, and we may have time to do some of them. What I want to talk about is the legal response to child sexual abuse, subcategory, tremendous progress, and room for improvement, obvious in the room for improvement. Now, I want to begin by saying that there has never been a time in our history when children were completely bereft of protection from child sexual abuse. Protecting children from physical and sexual abuse is not a new idea. Back in colonial times, you can find reports of people of goodwill and courage stepping up and protecting children. You can find prosecution of child sexual abuse in colonial times and forward. Not on the scale that we have it today, to be sure, but there was never a time when children were simply abandoned to this crime. Now, when it comes to organized child protection, if you've been to social work school, you've heard this story, of course, in your training. If you haven't been, maybe you haven't heard of it. But in the United States, organized child protection was really born in New York City in 1874 with the rescue of a little girl, then 8, by the name of Mary Ellen Wilson, who was physically abused by her caretakers, not her parents, but by her guardians. And a religious missionary to the poor by the name of Etta Wilson Etta Wheeler, I beg your pardon, stepped in and rescued Mary Ellen Wilson. And that led the next year to the creation of the New York Society for the Prevention of Cruelty to Children, the first society of its kind in the world that was devoted entirely to protecting children. We should say that from its earliest days, the New York Society intervened in sexual abuse cases. It wasn't their initial focus, but they didn't ignore the problem. Here's an actual picture of Mary Ellen, taken shortly after her rescue in New York City. You can see that she's in a threadbare dress, the only item of clothing that she owned. You can see that she's actually got a number of bruises and serious injuries. You can also see that she's got a fresh gash on her face where her guardian had cut her with a pair of scissors while they were working on a quilt together. So thank goodness she was rescued. Now, I always like to begin, when I talk about Mary Ellen's case, to emphasize the fact that Mary Ellen was rescued. She went on to have a happy, productive life and have children of her own. 2 girls who in the early 20th century went to college themselves, quite an accomplishment in the early 20th century. So the very first child protection intervention was a success story, not a failure. And we need to keep that in mind because every day, as you know, across this country, Mary Ellens are rescued by people of goodwill and courage. Now, societies for the prevention of cruelty to children were private organizations. The government played almost no role in early child protection other than the courts. And these private, charitably funded SPCCs spread around the country so that in the early 20th century, there was about 300 of them spread around the United States. You certainly had an important one here in Pennsylvania. We had one in California called the California Society for the Prevention of Cruelty to Children in San Francisco. This is a picture that I found that had been buried for more than a century in the archives at the University of California, Berkeley, of a little girl who was rescued in San Francisco. And the printing here says, this little 9-year-old girl was the victim of an unnatural, cruel mother who beat and starved her and compelled her to sleep on a cold, damp back porch among the refuse. The woman fled to escape punishment. Nourishing food and care soon restored the child to a normal condition. We placed her in a good home. What's interesting about this is that it's another success story of child protection. And you say, how did you find this picture? Well, in the early days of child protection, remember, child protection work was in the hands of private agencies, not the government. And they actually advertised their work. This is an advertisement for their work, a fundraising tool. Now, today, of course, child protection is shielded in confidentiality, but in the earliest days of our history, they would actually publish this work and distribute it to people who that they would try and open their purse strings with pictures like this, and you can imagine it was a pretty effective picture. Well, societies for the prevention of cruelty to children intervened against child sexual abuse, as I said, from the very beginning. In the early 20th century, about 10% of cases handled by the Massachusetts Society for the Prevention of Cruelty to Children were sexual abuse cases. This is documented by Linda Gordon in her great book, Heroes of Their Own Lives, published back in 1988. So child protection, when it became kind of official and organized, did intervene to protect sexual abuse. Not on the scale we do today, again, but it was occurring. One of the early leaders in child protection in the United States was a gentleman by the name of Karsten, who was the director of the Child Welfare League of America. And in 1937, this is what Karsten had to say about child sexual abuse. He wrote, "We have recently become aware of what seems to be a wave of brutal child murders. But for every case of child murder accompanied by sex abuse, there are probably hundreds or more cases of rape, incest, and other sex crimes against children, often girls not yet in their teens." So child protection authorities were aware of this. They tried to intervene with the tools that they had available to them at the time. Another important component of child protection, of course, is our juvenile court system. The juvenile court was created in 1899. Either in Chicago or Denver, and there's a dispute about that depending upon whether you live in Chicago or Denver. We're not going to resolve that dispute, but suffice to say that the juvenile court spread quickly across the United States, so that within a few years it was existent everywhere. I'll give you the argument that it was Denver, because here's Denver's first juvenile court judge. This is Ben Lindsay, who worked as a janitor to become a lawyer in Denver in the late 1800s and was appointed to the juvenile court bench. He was a very colorful character of the Old West. He made a lot of political enemies, but did a lot of good for kids as well. And here's an actual picture of Judge Lindsay's courtroom. This is the juvenile court in Denver in the early 20th century. Do we have any probation officers here? Raise your hand if you're a probation officer. No probation. Where are they? I don't know. But just to tell you who we are, this is Judge Lindsay here, right? And he's behind, it's not a normal courtroom, of course, because it's a juvenile court. Here we have 3 young boys who have done something wrong. We don't know what, but they're in trouble, so they're appearing before the judge. Here we have the Mountie hat, see it? This is obviously the trooper. This is the police officer. And this big hat, see this hat? This is obviously the probation officer. That's pretty obvious, isn't it? Because in the earliest days of the juvenile court, probation officers were all volunteers, and they were almost all middle class or wealthy women who all had big hats, because it was the fashion. So you could always pick the probation officer out. It was the one with the hat. So that's the probation officer. Who these other guys are, I don't know, but there is Judge Lindsay dispensing justice in an early juvenile court. And the juvenile court, of course, hasn't changed that much. It's still not a traditional courtroom in many respects of the word in most jurisdictions. The juvenile court in those days protected children from sexual abuse. It still does it every day today. It's not perfect, but the juvenile court is one of the great ideas of the progressive era in this country. Now, during the 20th century, there was a gradual shift from private child protection to government CPS, as we know it today. A lot of people are surprised to learn that private child protection societies were operating in decreasing numbers into the 60s and 70s in this country. It wasn't really until the late 1970s that CPS, as we know it today, as an entirely government-operated institution, really was firmly in place. Let's talk about the modern era of child protection. Many of us who write about the history of child protection would say that really the modern era began, if you want a bright line, in 1962. So what happened in 1962? This is a little quiz. What happened in 1962? Well, it was the publication of the Battered Child Syndrome in the Journal of the American Medical Association. There were other reasons, of course, but this enormously influential article published by pediatrician Henry Kemp and his colleagues in JAMA. And notice how long the article is. 2 pages. Launched the modern era of child protection, in many senses of the word. It really helped to kindle interest in the medical profession when it came to physical abuse. Here's a picture of the first author, C. Henry Kemp, the chairman of the Department of Pediatrics at the University of Colorado Medical School. And not only was he the first author of this article, but he was an active voice, a leader in getting the United States, in medicine in particular, but the Congress as well, to wake up to the fact that our child protection system was not up to snuff. Recognition of child sexual abuse in the late 20th century, the second half of the 20th century, lagged behind recognition of physical abuse. It was really recognition of physical abuse and the battered child syndrome that brought the issue into professional and public awareness in a large way. Vincent de Francis, who is a name that I'll bet many in this room have not heard before, which is unfortunate because he's one of the pillars of the child protection system in the United States. Here's a picture of him. He was a lawyer by training in New York, and then he went to work for a child protection society in New York. He quickly realized doing casework that his training as a lawyer did not equip him to be a caseworker. So he went back and did training in social work. So he's really a lawyer and a social worker. It's a pretty good combination. And this is a picture of him after he became the director of the Children's Division of the American Humane Association in Denver. He was one of the most brilliant and forward-looking thinkers about child protection that we've ever had. And he's almost virtually forgotten these days, which is really unfortunate because he played an enormously important role. De Francis conducted one of the earliest large-scale studies of the prevalence of child sexual abuse, published it in 1969. And it was a very thorough and large-scale study. And in his study, called Protecting the Child Victim of Sex Crimes Committed by Adults, he wrote, "The problem of sexual abuse of children is of unknown national dimensions, but findings point to a probability of an enormous national incidence, many times larger than the reported incidence of physical abuse of children." Henry Kemp, the pediatrician, such an influential figure, gave a speech to the American Academy of Pediatrics in 1978. The title of the speech was "Sexual Abuse, Another Hidden Pediatric Problem." So the first hidden pediatric problem was physical abuse of children. And then in 1978, he said, listen, we as a medical community are not paying attention to sexual abuse. This is another hidden pediatric problem. David Finkelhor, who has left, but who was here yesterday. Now, David didn't say this, so I'll say it for him. He wouldn't say it. But David is really an historic figure. He's one of the world's leading researchers, but he has a place in the history of child protection in the United States for many reasons, but I think primarily because of the publication of this book. This was a groundbreaking piece of research that David published as a book. The Sexually Victimized Children in 1979 really is principally, well, not principally, but in a major way responsible for our current awareness of the prevalence of child sexual abuse. And of course, Dr. Finkelhor has continued to carry that torch forward until today. Here's a picture of him, in fact, the great man, with this attractive woman, not his wife. I know that because it's my wife. Keeping an eye on the great man when we were in San Diego. He wanted to go to the botanical gardens, so we had to go to the botanical gardens. But my wife, Kim, was all excited about it, too. So those two had a great time. So there has been enormous progress when it comes to responding to all forms of child maltreatment and child sexual abuse in particular. Enormous progress, and we shouldn't belittle the progress that has been made. Progress, yes, but progress that had to be made pulling against a long legacy of skepticism about victims of child sexual abuse in particular. And when we talk about victims, I need to add adult victims of rape, because adult women who alleged rape and children who alleged sexual abuse were lumped together and viewed with enormous skepticism for much of our history. And it's important, I think, when we understand where we are today to understand just a little bit about this legacy of skepticism. This is a fascinating story which we could spend hours on, but Sigmund Freud himself contributed to the skepticism with his seduction theory, which we don't have time to go into now. There's a wonderful book by Geoffrey Masson, The Assault on Truth, Freud and Child Sexual Abuse, published in 1984. It's a fascinating read. I would recommend it to you. Freud contributed to the doubts about the credibility of accusations of rape and sexual abuse in ways that are interesting. You can take a look at the book. If you look at the pre-1970 psychological literature, the psychiatric and psychological literature on child sexual abuse in particular, there are some themes that you find in the literature that can be summarized as follows. Children are responsible for their own molestation. It's their fault. Children are seductive. Of course, this is what often what perpetrators say, right? She was a seductive kid, it wasn't my fault. So this was a theme that was picked up in professional writing. Children are often responsible for their own molestation. And if they're not responsible, then their mother is. Of course, if you read early psychiatric theory, mothers were usually responsible for everything, right? All kinds of psychiatric problems. So mothers are to blame for the sexual abuse of their children, usually because the woman was a frigid, cold, asexual person, and the man had to turn to the daughter for satisfaction. Sexual abuse is rare, so it's not really something we should worry too much about. And finally, sexual abuse does little harm. So again, why should we really devote much attention to it as a social problem? These are themes that you'll find, not universally, but quite dominant in the early psychological literature. Now, of course, I'm not a psychologist or a psychiatrist or a social worker, so I read that literature as a layperson, but I do know how to read my own literature. So I read the legal literature on rape of adult women and sexual abuse of children and tried to synthesize it down. And I came up with really two dominant themes in the early legal literature. The first was what I call fear of fabricated allegations. This is pervasive in early law review writing about rape and sexual abuse of children, is the fabricated allegation. And then related to that, of course, is fear of crazy women. And I think that's the best way to describe it, is that women who alleged rape or children who alleged sexual abuse are probably crazy. Probably crazy. They're either vindictive or they're crazy. You take your choice, or both. Both. And so you can see the way this would fuel the skepticism with which victims were greeted. John Henry Wigmore, about whom I'll tell you in just a moment, wrote in his very influential treatise on the law of evidence in 1904. So you have to give the context. This is 1904. Wigmore wrote, "No judge should ever let a sex offense charge go to the jury unless the female complainant's social history and mental makeup have been examined and testified to by a qualified physician. It is time that the courts awakened to the sinister possibilities of injustice that lurk in believing such a witness without careful psychiatric scrutiny." In other words, Wigmore is saying 100% of women, without exception, need to be seen by a psychiatrist before being permitted to testify. Every one of you is so likely to either be crazy or vindictive that you need to be evaluated before we permit you to testify. And this is not kids we're talking about, this is women. The same, of course, goes for children. John Henry Wigmore is a name that if you had the good sense not to go to law school, you probably haven't encountered before. But he was the most brilliant scholar of the law of evidence that the country has ever produced. He was a law professor at Harvard in the early 20th century. And his great achievement was synthesizing thousands of cases on evidence into a coherent body of rules that are the rules I teach today to my evidence students. He was the great synthesizer of the law of evidence that we use in our courtroom. But of course, he was a consumer of the psychiatric and psychological literature and the thinking of his time. It's not surprising that he would have come to this conclusion. The reason I quote Wigmore is because Wigmore was the most influential legal scholar of his time when it came to trials. And when Wigmore spoke, judges and lawyers listened to what he said. Special rules emerged in rape cases and child sexual abuse cases. The testimony of a victim in a rape or sexual assault case was so likely to be a lie or the result of a delusion that it could not be trusted. There had to be corroboration. That's not required for any other crime except sex offense crimes. If a defense attorney asked for a psychiatric evaluation of the victim, he was to have it. Wigmore said 100% of women should be subjected to psychiatric evaluation. And special rules regarding courtroom procedure evolved in rape and sexual abuse cases. If the woman was unchaste, for example, the defense attorney would routinely bring out the fact that she was unchaste. The thinking was, if a woman was unchaste, she probably consented. Of course, if you consented, it's not rape. And the same kinds of theories were applied even to children. So we had a long legacy of doubt and skepticism about women and children who made allegations. And the same skepticism extended to boys who made the allegation, maybe so, even greater extent. So again, the progress that we've made is despite this legacy of skepticism and doubt about the credibility of victims. By the way, it all changed in 1975. That's a slight exaggeration. But 1975 is really a pretty dramatic cutoff point. It really began in the psychiatric and in the legal literatures especially in the 1970s, really peaked in 1975 in the late 1970s. Now what changed in law schools, just by way of limiting it? What changed in law schools in the 1970s that would have led to a change in the legal literature? Women. It was the 1970s that you saw women coming to law schools in large numbers for the first time. And it was in the 1970s that you saw women become professors for the first time. And I'm sure, and it was also, of course, that happened in the context of the women's movement. This is all about the women's movement of the 1960s and 1970s, that we saw the rape reform movement and we saw changing attitudes toward victims, which were quickly reflected in professional writing about the subject. But just to give you one final example of the skepticism, the very first rape case that reached the California Supreme Court, 1855, I believe it was a case involving 13-year-old Lavinia Dickey, who alleged that the person that she lived with, a farmer that lived in the Sacramento area, not her dad, don't know where her parents were, can't remember, but she was living with this farmer, and he repeatedly raped her at different places around the farm. The case was brought to trial by the prosecutor as a rape case. The jury took 40 minutes to convict the guy. Lavinia testified she did a fantastic job. The defense attorney tried to confuse her. She would have none of it. She was a great witness. And the jury accepted her testimony, and he was convicted. The case went to the California Supreme Court, and the Supreme Court rejected the jury's finding and reversed the conviction. This is what our California Supreme Court said in 1856. There's the date. There is no class of prosecutions attended with so much danger or which afford so ample an opportunity for the free play of malice and private vengeance. Reverse the conviction. You know, victims are not to be trusted. And this is an early example of this that found its way into an appellate decision. But I want to go back to progress now. Psychological and legal literatures changed dramatically in the 1970s, as I said. CPS, Child Protective Services, as we know it today, took shape in the 1970s and then finally crystallized into the 1980s in the form that we interact with it daily today. Reporting laws appeared. The first reporting law, child abuse reporting law, was on the books in 1963. And by 1967, all states had reporting laws. Interestingly, at least I think it's interesting, two of the principal forces behind the creation of reporting laws were Henry Kemp and Vincent de Francis. They were at the first meeting at the Children's Bureau in Washington, D.C. that broached the idea. But it very quickly spread around the country. Every state, of course, has a reporting law on the books today. Pennsylvania's reporting law, which I understand is under revision right now. You guys are working on it, which is great, but it's typical of reporting laws around the country. Basically, anybody who comes within 100 miles of a kid must report. That's the law. Coming within 100 miles of a kid, you must report. If you're a professional and you work with kids in any capacity, in your state, my state, any state, you're a mandated reporter. Of course, training people about their reporting duties is another matter. But anybody who works with kids must report. It says when the person has reasonable cause to suspect on the basis of medical, professional, or other training and experience. That's what your law says. And then, of course, you also have a voluntary reporting. Any person in Pennsylvania may report. Professionals, the vast majority of people, maybe everybody in this room, must report if you work with kids, but anyone can report. So the reporting laws were a major step forward. The work of Dr. Finkelhor, Mr. de Francis, and others, and then when you combine their work with the other research on the prevalence of child abuse and the reporting laws, they really wrenched the secret out of the closet where it could no longer be ignored. One of the things that we see during the mid-20th century is what were often called psychosexual psychopath laws. They began in Michigan in 1937. These are special laws dealing with sex offenders. By 1960, 29 states had these laws. One of these laws, for example, was a law that allowed authorities to put a dangerous sex offender in a psychiatric hospital after they were done with their prison sentence. They could be put in a psychiatric hospital. Involuntary psychiatric hospitalization. These laws, these dangerous sexual psychopath laws, largely fell into disuse in the 1970s and 80s. But they were resurrected in the 1990s. So today we have sex offender registration, which we heard about yesterday, which has many benefits. And one of the principal ones that was mentioned is that the police, when a crime occurs, they use these sex offender registries to generate a list of suspects so that they can begin their investigation. That's a good thing. We have Megan's Law, named after Megan Kanka, who was brutally murdered in New Jersey by a sex offender who her parents did not know lived directly across the street. Megan's laws allow public notification of sex offenders. Megan's laws are controversial. I'm not going to get into the controversy, but they are an emblem of society's statement. We ain't going to take this no more. We're going to do something about it. There's residence restriction laws that, and this was mentioned too yesterday, but laws that forbid sex offenders from living within a certain distance of a school or a park. Now, I personally think these laws create all kinds of serious problems, which was mentioned yesterday, like homelessness and so forth. But it's open for debate whether these laws do more harm than good. And then here's a picture of Adam Walsh. Most of us have seen his dad on America's Most Wanted. Adam was brutally murdered. There is now a major federal law named the Adam Walsh Act, which does a lot of things in terms of funding efforts to protect children from sexual abuse. We don't have time to go into it, but I just wanted to give these as illustrations of our state legislators, our federal legislators, our president have, we're continuing to try and work on this problem in a major way. It's not a problem that's ignored anymore. One of the greatest achievements when it comes to responding to child sexual abuse is improved interviewing of children. If there's an area that we've really made measurable progress in, apart from therapy, which you heard about a little while ago, it's the way we investigate cases. Now, investigations fall through the cracks all the time, right? We mess up investigations every day. But investigating child sexual abuse has come a long, long way. And then part of that credit for that is improved interviewing of children. In the 1980s and 1990s, psychologists investigated children's memory and suggestibility. Now, that's not that they had ignored it before, but it was the 1980s and 1990s when a whole cadre of very bright psychologists and psychologists around the United States and around the world studied children's memory and suggestibility in ways that redounded to our ability to interview children better. Here's an example. This is Gail Goodman in Paris. Now, if you don't know who Gail Goodman is, this is the only picture I could get of Gail. Gail is one of the world's leading authorities. You can tell she's one of the world's leading authorities because she's in Paris. She's all over the world. When I talked to her last week, she was in Buenos Aires. She's a professor of psychology at the University of California, in Davis, and she's one of the real pioneers in studying children as witnesses, children's memory, children's suggestibility, and I'm sure she's at some official function there in Paris having a terrible time. Looks like she's having a terrible time. The first Child Advocacy Center was established in 1985 in Huntsville, Alabama, and the Child Advocacy Center, as you know, is that place to which children can go and be interviewed by someone with extensive training in how to talk to children for forensic purposes. And this is the great advance, really talking to children for forensic purposes in a way that is developmentally sensitive, but that gathers evidence that we can use in court that hasn't been contaminated. That's the real progress that we've made when it comes to interviewing. So the first Child Advocacy Center in 1985, I guess 900's wrong, right? 850. 850 child advocacy centers scattered around the United States today interviewing kids. The National Child Advocacy Center in Huntsville, Alabama, which is the outgrowth of that first Child Advocacy Center. You just, Google these folks if you don't know about them already. They provide great training on forensic interviewing and other kinds of activities. The executive directors here today, raise your hand, stand up. Go buttonhole him after the talk. His name is Chris Newland. He's a great guy. He'll give you all the information you need to know. Interview protocols, how to talk to children. There's been enormous development in reducing proper interviewing techniques to protocols. The National Child Advocacy Center has a protocol. The National Institute of Child Health and Development, which is part of NIH in Bethesda, came up with an investigative interview protocol. I don't know if any of your jurisdictions use the NICHD protocol. Here's the guy that created it. He wasn't alone. He had lots of collaborators, but this is Michael Lamb, who for many years was at the NICHD in Bethesda. He is now the head of one of the psychology departments at Cambridge University. Pretty smart guy. So he's at Cambridge in England, still working on the NICHD protocol. Now, the reason I like the NICHD protocol so much is because they decided to come up with a protocol for interviewing children, and then they decided, well, let's see if this actually works. Let's prove this. And so Michael Lamb and his colleagues have a deep well of rigorous empirical research proving scientifically that this protocol is used, that it yields more information, and it does not contaminate children's memory. It's a research, evidence-based protocol, and if you're interested, you could ask me, or you could drop Michael a line. I'll give you his email address. Here's two of his books. If you're involved in interviewing, these are books that you want to know about. These will be available, so you don't need to try and write this down. They won't be available long enough to write it down. But two of his books, Children's Testimony, a Handbook of Psychological Research and Forensic Practice, and his other book, Tell Me What Happened, Structured Investigative Interviews of Child Victims. Really must reading for any of you who interview kids. I'm sure those of you who do already know about Dr. Lamb's work. Proving child sexual abuse in court. The investigation is important. The interviewing, the evidence gathering, very important work. But then, in some cases, of course, we have to prove it in court, whether it's a criminal proceeding, a juvenile court proceeding, or a family court proceeding, about which I'll say more in a moment. Children as witnesses, we've learned a great deal about how to make the legal system more accessible and less difficult for children. Here's a couple of books. One by Susan Hall and Bruce Sales, Courtroom Modifications for Child Witnesses, published in 2008 by the American Psychological Association. I've written about it myself in that book. This is an area where I think we've also made enormous strides in the United States in terms of helping children testify in court. Because in our legal system, ladies and gentlemen, children have to testify in court. You can't change that unless you amend the Constitution, which you're not going to do. Because those of us who think that it's a good idea wouldn't let you even if you wanted to. In our Constitution, of course, in the United States Constitution, and in every state constitution, there's something called the Confrontation Clause. Most countries don't have the Confrontation Clause. England does not have a Confrontation Clause, for example, but we do. It's the Confrontation Clause, which is part of the Sixth Amendment to the United States Constitution, which guarantees the defendant in a criminal case the right to confront the witnesses against him, face to face. This is a fundamental constitutional right in our system of law. It's because the defendant has a fundamental Sixth Amendment right to confront the witnesses against him, including 6-year-old witnesses, including children, that children in our system must testify in the physical presence of the defendant. It's a Sixth Amendment right. Now, it is true that the United States Supreme Court, in a case called Maryland against Craig in 1990, said, if you have a child who would be particularly traumatized by testifying in the physical presence of the defendant, that particular child does not have to testify in the physical presence of the defendant. But that is a very rare exception to the general rule. So many professionals think that testifying in court is something that is inherently traumatic for children. I will grant you this, it ain't no fun. But of course, I put people on the stand all the time, and it's no fun for them either, and they're like 35. Who in the heck likes to testify? Nobody that I know of likes it. But the takeaway message I would leave you with this is this. In our system of law, children must testify in many cases. In fact, unless children testify, the legal system simply cannot protect them because they have the most powerful evidence. So what we need to do as professionals, legal professionals and non-legal professionals, is find ways to make testifying less difficult for children. And we're doing that. Prosecutors today give children a tour of the courtroom so that they understand it. They sit in the witness box. They answer some questions that don't have anything to do with their case. They can run around the courtroom if they want. If there's a bailiff handy, you bring the bailiff in so that the child knows this is a safe place. This is a policeman, and they will keep everybody safe. Because lots of children who go to court think that they will be attacked or that they'll be yelled at, in many cases because that's what they're used to. Now, it's not that all children understand. But giving children a tour of the courtroom helps them reduce their stress, just like doctors will often give a child a tour of the hospital or something like that so that they're familiar with it. It's important because if children don't have the tour of the courtroom, they can make mistakes. For example, there was a little boy who was brought into the courtroom to be asked some questions about whether he would be permitted to testify. So the courtroom was empty. It was just the lawyers and the judge. And the judge said now to this 5-year-old, said, now, do you know where you are? And the little boy looked around and said, well, I guess this must be the police station. And you must be a karate expert. And if you think about it, that's completely logical, right? He hadn't had the courtroom tour, so he didn't know. So here we have a cop. So what do you think this is? Must be the police station, right? And the judge had this black robe on, right? Looked like a ninja guy, right? So must be a karate expert. Perfectly logical answer. Would have been better if that kid had had a little tour of the courtroom in advance. Judges don't learn anything in law school about children as witnesses. Even if they take my course on juvenile law, we spend 10 minutes on it. Most judges, of course, were either prosecutors or defense attorneys, so they have some experience with children as witnesses, maybe. But many judges did insurance defense work for 30 years. They know nothing about children other than their own children. We're convinced of one thing. Judges, by and large, are terrible interviewers of children. They're just awful. We actually experimented with this a little bit. They're no good at it. Most of them are trainable, but not all of them, because they have very little exposure to children other than their own kids for the most part. I'll give you an example. In order to testify as a witness, you have to understand the difference between truth and falsehood. And you have to understand your duty to tell the truth in court. So this judge, trying to do his best, was interviewing this little 7-year-old. And the judge says, what will happen if you tell a lie here in court? And the child said, I could go to hell. And the judge said, is that all? And she said, isn't that enough? And the judge went like this, what did I ask that question for? So, despite that little snafu there, we are much better at preparing children for testifying and getting them through this difficult experience. Dr. Goodman's work is the leading work on children as witnesses. And what we find is that when children are prepared and emotionally supported, not surprising, is it? When children are prepared and they receive emotional support from their parents, victim advocates, or others, it's a difficult experience, but they get through it okay. And most of them have no lasting psychological sequelae from testifying. Children can testify accurately, for the most part, without lasting psychological trauma. This is the leading authority these days on children as witnesses. His name's Thomas Lyon. He's both a lawyer and a PhD psychologist. He's a wonderful guy. He's at the University of Southern California in Los Angeles. If you want to do training on children as witnesses, go on Tom's website. Just Google Thomas D. Lyon. All of his research is on there. It's the best stuff on children as witnesses that you could find. We've made enormous progress in prosecuting cases of child sexual abuse. I'll give you an example from Pennsylvania. If you look in Pennsylvania statutes, we find the legislature has said is the policy of this state to protect children involved in the criminal justice system. And such policy statements have value. The child's name must not be disclosed in legal proceedings to protect their confidentiality. If a particular child would be traumatized by testifying in open court, there are alternatives in those cases where the child simply can't go forward. And then Pennsylvania, like most other states, has enacted a special hearsay exception for children's reliable out-of-court statements. That statement they make in the hospital to the nurse, the doctor, the CPS worker, the police officer, or their mom or dad, or their best friend. When they disclose, what they say is hearsay if it's repeated in court. Now, of course, the rule is hearsay is inadmissible unless it's not. That's the rule. Hearsay is inadmissible unless it's not. There are 32 exceptions to the hearsay rule. For the next 3 hours, I will tell you about these exceptions. Well, maybe not, because Elizabeth is coming up next, right? So we won't tell you about any of them. But the point is, children's hearsay statements are often the most powerful evidence of child abuse. More powerful than anything they say on the stand, and much more powerful than any expert says on the stand. And you have a special hearsay exception in California, in Pennsylvania, as we do in California. So we've made enormous progress when it comes to investigating and prosecuting child sex abuse cases. There's controversy still on expert testimony, for example. I think I won't go into this. We can come back another day and do this. Expert psychological testimony, I'm not going to do that. I want to get very close to the end here by talking about allegations of child sexual abuse litigated in 3 courts. We have criminal prosecution of child sexual abuse, which is what people think about, right? Certainly it's what the lay public thinks when they think about child sexual abuse in court. They think about the criminal prosecution. And then we have child protection proceedings in our juvenile courts around the United States, where children who have been or alleged to be sexually abused in their own homes are protected, and cases come into the juvenile court for adjudication for protective purposes. Actually, our juvenile court system is much more important to a large number of children than the criminal justice system. I don't want to downplay the importance of the criminal justice system, but it's our juvenile court systems which are in confidence, which are in secret, which protect children every day from child sexual abuse that's occurring within the family. And then there are allegations of child sexual abuse that come up in family court. This is the contested custody case, incident to a divorce or not, between parents where one parent accuses the other of child sexual abuse. When it comes to evaluating allegations of child sexual abuse, the family courts in this country are not working. They are broken. I can't swear to that in your state. I'm 100% sure in my state of California that it is the family court that is the least effective when it comes to responding to accusations of child sexual abuse. There's a whole bunch of reasons for that we don't have time to get into. But I will tell you this. Remember that long legacy of skepticism that we overcame in the 1970s? We overcame it, but not in family court. It's alive and well and growing, in my opinion, in family court. All you have to do is spend 15 minutes in a family court, and I practice family law as well as teach family law, to realize that the level of skepticism of allegations of domestic violence or abuse of children is absolutely through the roof when you go into family court. So if there's an aspect of our legal system and its response to child abuse that is not working well today, don't get me wrong, many family court cases are resolved well by people who do the right thing. But when it comes to the level of skepticism and the dysfunction in the courts, don't focus on the criminal justice system. Don't focus on the juvenile justice system. Focus on our family courts. The system is broken when it comes to evaluating of accusations of child sexual abuse in our family courts? I don't have the answer to that. I wish I did. But we need to, I think, focus the attention of people like the experts we have here at Penn State and others around the country on trying to do something about our juvenile, our family court system. It's in trouble right now. Family courts fail too often in this case. I wrote a book about it a long time ago, it's called A Mother's Nightmare, Incest, a Practical Legal Guide for Parents and Professionals, because over and over again I kept getting, and I was talking to Dr. Finkelhor about this yesterday, he has the same issue. Over and over again I would get calls from women, it was always women, once it was a man, it was always women, who had made an accusation of child sexual abuse in family court and had lost their child. And by the time they called me, they were completely broke and their child had been taken away from them because they made the allegation. Of course, I'm just a professor. I can't do anything except write a book, so that's what I did. So this is a book which tries to affirm that our legal system is there to protect kids, because I believe in our legal system. I really do. But in the family court situation, it's primarily mothers who make these accusations. What they need to understand is there are so many things that can go wrong in family court if you make this accusation prematurely. So one of the things we need to do, I think, is school ourselves and school our colleagues about the dangers of taking an accusation of child sexual abuse into family court. Not to say that it shouldn't be done, because many times it should be, but boy, can things ever go wrong fast in family court. That's another 6-hour lecture. We'll do that at about 10 o'clock tonight. So, child sexual abuse, of course, is a scourge, and it leads to lasting trauma, as we've heard from some of the country's leading experts about this subject. And this is a picture from a book published in the 1800s about a little boy who's obviously in a bad way. We don't know exactly what happened to him. We can tell he's poor, he's probably neglected, he's despondent and despairing. But I don't want to end with that, because this is mostly a story of progress, not failure. The overwhelming story is one of progress when it comes to protecting children. So I want to end with this picture. The kindly police officer leading this little boy by hand into a courtroom where he will be safe and he will be protected. Safe and protected. Let's stop there.
Lots of questions for you, John. The first one is, what would you say is the biggest legal hurdle that we have yet to overcome in the protection of victims of abuse?
The biggest legal hurdle. That's actually a really hard question. So, I think it's always going to be hard to prove. We're never going to make it easy to prove, except in the easy cases. But that's true of any kind of maltreatment, right? I mean, bank robbery is easy to prove. You got the videos of the bank robbery, right? The only question in bank robberies, what's the only legal issue in bank robberies? Who done it, right? That's the prosecutor's not going to have a hard time proving there was a bank robbery. I didn't do it. I was in Mississippi delivering cookies that I baked myself to my invalid grandmother. That's the defense in bank robbery cases. The problem with proving child abuse and child sexual abuse is proving that anything happened. The bank robbery is easy to prove that something happened. In child sexual abuse, it's proving that anything happened. And there we have to rely upon the testimony of this little guy. Right? And that raises the whole issue of children as witnesses and the reliability of what they have to say. I think the legal mechanisms are basically pretty good. Our legal infrastructure, in terms of the rules of evidence, the rules of trial procedure, our enormous progress in investigating these cases are basically there. I think the real problem is, and has and continues to be, training of the professionals, such as myself, such as the lawyers, the judges, the investigators who work in the system. Because we turn over, you know. I mean, you know, whether you're a cop, a prosecutor, a public defender, a judge, you're not going to be doing that work for a long time, and you're going to have people that are new. They're always going to have people that are new. So I think training people to be fair to both sides, got to be fair to both sides, some accusations are not true, is the biggest legal hurdle. So it's not really a legal hurdle, it's a training hurdle.
Okay, John, next question is, in most cases, a spouse knows that their partner is a child molester. Therefore, should that spouse be held accountable for the spouse/predator's abuse of children, and can they be prosecuted?
Next question. So there is a small body of case law dealing with accomplice liability for parents who do not protect their children. You have a legal duty to protect your children. You have a moral duty, but you have a legal duty, and failure to protect your child is actionable. It's a crime. And parents have been prosecuted on one of two theories: the fact that they failed to protect the child, which is itself an offense, or that they were an accomplice to the perpetration of abuse. Now, I won't go into the details of that. The accomplice liability is not a good fit in virtually all cases, because the parent who fails to protect doesn't want their child to be abused. They don't share in the intent that the crime occur. They just either can't or usually can't protect the child. And you have to intend that the crime occur to be an accomplice. So, but at any rate, accomplice liability is one way that people are sometimes prosecuted. And I have seen cases where and it's usually a mom, not surprising, where a mother is prosecuted as an accomplice or for her failure to protect in physical abuse cases. It's more common in physical abuse cases where the boyfriend or the husband is physically abusing the child. But the same legal theories can be used to prosecute a woman for failure to intervene in a sexual abuse case. And there are such cases. And there are some cases where the prosecution is appropriate. And there are cases where reasonable minds can differ about whether the prosecution is appropriate. And I am 100% sure there are many, many cases where prosecutors refuse to prosecute because they look at the facts and they say this is a woman who couldn't, because of her own victimization or for whatever reasons, protect the child, and they don't go forward. So we shouldn't think that simply because there are some cases where, quote, protective parents are prosecuted, that the system is irretrievably broken, because there are many more cases where prosecutors don't go forward and try to get, in many cases, help from the person. So it's not an easy question, because there are those cases where the woman should be prosecuted, in my opinion. They're very rare, though, because most of the time the person is not in a position where they can protect. I'm troubled by those cases when I read them, because I do. That's what I sit around and do is read appellate law most of the time.
The next question is, how can we protect a child from ongoing abuse if that child is too traumatized to testify or disclose the abuse in a forensic interview, but has made disclosures to therapists?
Well, that's another good question. Of course, the disclosure to the therapist is hearsay. It's admissible evidence. And I would say that in many cases we can protect the child. Now, we have the issue of hearsay is not admissible unless it is. We have to deal with that, right? Because there is the rule against hearsay. And not all hearsay is admissible. But there are many cases where disclosures to therapists are the evidence that protects a child. And if you can't protect a child in the criminal justice system because you can't meet the highest evidentiary burden of proof beyond a reasonable doubt, if it's an intrafamilial abuse case, you may well be able to protect that child through the juvenile court, where the standard is the preponderance of the evidence, a much easier standard to meet. So I don't think I agree to the idea that well, it is harder, right? If you got a child who can get on the stand and describe what happened, and juries listen to kids, I mean, they really do. You're not going to get a better witness than a kid who tells a convincing story on the stand. They are the most powerful evidence you'll ever get as a prosecutor. But there are kids who can't testify or won't, and they haven't disclosed, or they may have disclosed to a friend, or in this case, a therapist. Now, if it's disclosure to a therapist, you bring that case to me, I'm going to evaluate it if I'm the prosecutor, and if I can convince a judge that hearsay is admissible, I think we could carry the burden with that. Not always, but in some. And there are times, and this is, of course, very frustrating. It's horribly frustrating for parents whose children have been abused, that the legal system simply can't do anything. I mean, we're never going to cure that. There are times when the evidence just isn't there. A prosecutor is ethically obligated not to bring a charge unless they can prove it. It is unethical for a prosecutor to bring criminal charges that they don't believe they can prove. And it's a very high burden that is deliberately placed on the government, because we sure as hell do not want to convict innocent people, right? I assume we would all agree with that basic proposition. And so there's going to be cases, and in the case of child abuse, particularly sexual abuse, which is so dependent upon the child, where there's simply nothing the legal system can do. So we're going to turn it back to you. Because that child can still get therapy, that child can still be in an environment where they may be protected, but maybe not through the legal system.
Okay, John, can you speak to the prosecution's last investigation of delayed child sexual abuse reports, specifically cases reported by adults who were victims as children?
Well, there's the immediate problem with, prosecuting a case of a 22 or a 32-year-old person who was abused when they were a little kid is the statute of limitations. There is a statute of limitations on all crimes except murder in the United States. And that's why you can have cold case murder prosecutions that are 30 and 40 years old. There is no statute of limitations on murder. There may be in Pennsylvania, I'm not sure, but I doubt it. There's no statute of limitations on murder, but there are statutes of limitations on other crimes, and for good reason. A crime that occurred 20 years ago, how are you going to defend that accusation? I know we're focused on the prosecution side of it, but suppose you're the accused. How are you going to defend that? The witnesses are dead. They've moved away. They can't remember what happened 20 years ago. The statute of limitations is in place because eventually it becomes unfair to the accused to defend. It becomes harder and harder to defend as more time goes by. Okay, so that's the reason for the statute of limitations. A number of states, I don't know if you did it here in Pennsylvania, but a number of states extended the statute of limitations in child molest cases. My state did. Of California, we have an extended statute of limitations where a person could bring a claim within a window of years and bring their claim late. But it creates all kinds of proof problems. That's the hard problem with it, is proof problems. You've got memories that are decades old. You've got witnesses that are no longer there. So, I mean, some cases, sure, especially if you've got solid corroborative evidence. If you've got, like that little girl who had the genital injuries, and maybe a convincing disclosure, which she can repeat over years because she still remembers it. And maybe the perpetrator isn't caught for 20 years. Well, that case we can prosecute, as long as we have a statute of limitations which can be overcome. So it's mostly a proof problem issue. I worry about fairness issues with stale prosecutions.
Okay, another question. I've heard it said that we live in a rape culture. Do you have an opinion on this question from a legal standpoint?
No.
Okay.
I don't even know what that means. What does that mean? I'm not going to get into that. Politicians have gotten in a lot of trouble lately. And they talk about that. I'm not going down that road. I know this. I know rape is an all too common crime, right? Mm-hmm. And that it can be difficult to prove, especially when it becomes a he said, she said encounter, which many of them become. But we've known that for 100 years, right? No. More than well over 100 years. But I don't know what a rape culture means, so I'm going to pass on that one.
Okay, well, it looks to me like we are out of time, right? Okay, so let's all thank John for his great talk.